while they're doing the picture, I'm going to introduce our next panel. And we're very honored to have remotely, unfortunately because of health issues, David Goldberger, who was in fact the legal and legislative director of the ACLU of Illinois and the lead ACLU counsel in the case of National Socialist Party of America against the village of Skokie. David's going to be joining us remotely via Zoom. Along with Allison Stanger, the Middlebury Distinguished Endowed Professor and co-director of the Getting Plurality Research Network at the Harvard Kennedy School, Emerson Sykes, Senior Staff Attorney with the ACLU Speech Privacy and Technology Project, and an adjunct professor at NYU Law. Please join me up on stage. So nice to see you, David. Thank you so much for beaming in. Maybe I'll start with you as someone who was involved in the case. I wanted to ask each of you, what does the Skokie case sort of mean to you? What does it stand for? And I want to ask you, David, specifically, because it was such a formative thing in your career. How did it affect your career going forward? What does it mean to you today?
Well, before I directly respond to that, I just want to say that there was a question about whether the ACLU is towing the line on the First Amendment today in the way that it was years back. I'm not quite as complimentary as Nadine and Aryeh, although I think the ACLU is doing wonderful work. I've been a critic of that aspect of the ACLU's work, however. But in terms of the impact on my life, on my career, it was formative. It's not the kind of case that you ever look for. It's kind of like being in an automobile accident and you discover yourself in the middle of it. But I never looked back or doubted the importance of the First Amendment. And even now, when I'm seeing a First Amendment under attack by the federal government and criticized for protecting hate speech, we did the right thing, and I'm not going to spend a lot of time explaining now how, although willing to talk about it as we move through the panel.
Thank you. Emerson, new generation of the ACLU, how would you answer the question? What does Skokie mean to you?
Well, thanks so much to the organizers. It's a pleasure to be here. We've been talking a lot about the ACLU. Are there any other ACLU current employees here? No. Okay. So I'm the only one whose ears have been burning.
We're going to believe you, whatever you say. So.
No. So, well, what Skokie means to me has changed tonight because I am one of those people whose parents, my dad, used to always tell me the story that he had helped create a chapter of the ACLU in his hometown of Shreveport, Louisiana, and that he had left the ACLU, say it together, because of Skokie. And now that you question this, Aryeh, the years don't match. So he may have been making this up the whole time. So now I need to go back and fact check. Unfortunately, he's no longer with us, but I need to go fact check my dad's ACLU Skokie story. So I thank you very much, Aryeh.
Allison.
Well, thanks so much for having me here. I was born in Chicago, so it's always wonderful to be back here. And the Chicago principles mean a lot to me. So thank you for those as well. The Skokie case to me is kind of the litmus test case for free speech absolutism, right? But even today, I learned something quite valuable from Aryeh because I had always assumed that the Nazi Party had intentionally chosen Skokie to antagonize the inhabitants. And the reality is actually a little bit more complicated, which is a really good reason to give us pause, not to empathize with Nazis. I think that's what makes it so difficult in this case, because it's, how do you empathize with Nazis, right? But to realize that reality is often more complicated than it's presented to us in various forums. So, yeah, if you can allow Nazis to march in Skokie, I think that pretty much says that you have to respect free speech universally in this country.
Thank you. I gather you've been somewhat of a critic of absolutism, of free speech absolutism. Is that a fair thing to say?
You know, it's interesting that you say that because I think that's actually untrue.
Okay.
But let me clarify what I mean, okay? I've always called myself a free speech absolutist, and I stand by those principles. But I think today's age of social media and big tech, and I'm writing a book about this, transforms some of the First Amendment questions in an interesting way. So now I want to qualify what I say about free speech absolutism and say I am a human free speech absolutist. I do not believe the First Amendment protects machines and algorithms. And I think we need to make that distinction properly if we're going to somehow apply the First Amendment to the virtual public square as it exists today. That's where we have our dialogues. That's where civil society is in some respect.
Thank you.
Can I interject?
Please. Yeah.
Hi, Fred.
My concern is that giving government the power to make those decisions gives it the power to shut down law firms and universities and the like. I mean, the problem is, how do you set boundaries when you start to say, well, you know, this is okay to regulate and that's not okay to regulate because we really trust government in some areas. It's a conundrum that I don't think is easily dealt with.
Emerson, do you want to comment on absolutism? Is this the right approach? Is it?
Well, I mean, look, I'm glad you mentioned Charlottesville, right? Because we can talk about Skokie. Obviously, it's monumental. That's why we're here together. But it is not unique in the ACLU's history. It is not unique in the nation's history. And so, you know, in terms of, if the question is, you know, is the ACLU absolute? I think the absolutism is a bit of a misnomer, right? There are always exceptions. And the question is, how tightly do you want to cabin those exceptions? And I think we at the ACLU, I mean, we can get into more of the details soon, but, you know, I think we remain committed to these principles. I think the cases and show that, but the criticism comes around how tightly you're going to draw those very fine lines in individual situations. So there is daylight, there is room for criticism, there are decisions that we have made and positions that we have taken that I think are controversial. But at the end of the day, I don't think folks can honestly say that we have abandoned our principle or that there is a wide gulf between how we used to act and how we do act now. But I can talk more about the details of the then and now.
Yeah, I'm kind of interested in that question because Arya pointed out that the ACLU is not a national top-down organization. You're obviously in Washington, D.C. So, I think we're all agreed that if the case were to arise today, the ACLU should defend it. Would they? How confident are you that they would?
The ACLU would be involved. My honest answer to this is that the ACLU now would more likely be an amicus. The difference now, I know, and this is, so the interesting thing is this matters a lot to constitutional lawyers, right? The difference between an amicus brief and a direct representation, sorry, we're going a little into the weeds, but this is where we are. The difference between directly representing the Nazi Party, you are their attorney, your fiduciary duty is to them, you are to zealously advocate on their behalf. We do that sometimes. We represented directly the NRA. The NRA are not Nazis, obviously. I think the NRA case was extremely easy. I don't think it even belongs in the same conversation as some of these much more difficult ones. That was an obvious decision, in my opinion. But when we're dealing with speech and people who are actively doing things that are harming folks, we now have would more often figure out how we can defend the principle at play. We have not abandoned the principle by any means. while also mitigating the harm that can come from direct representation. So I think to the extent that we are open to criticism, and this is criticism that I'm sure David Goldberger will have, that I think is the distinction between an amicus and a direct representation. I will just say, before you pile it on, in either case, the headline will be, ACLU backs so-and-so. So to the vast majority of people, this distinction that I'm drawing doesn't matter. That doesn't stop the critics from both the right and the left and the center from coming at the ACLU. But if I'm being very honest, that is the distinction. I don't think it's a distinction in principle. I don't think it's a distinction in dedication. But I do think to the extent there has been any compromise, it's that we are more likely now to be amicus than representation. But it is not a categorical rule, and it is not something that we would never do.
David, do you have any comment?
And let me just recount a conversation I had with the executive director of the Illinois affiliate at the time of the Skokie case. We took the case, and I'm not going to spend the time here to explain the procedure that occurred, but before the board had a chance to weigh in. Now, we did not outrun the board. It was within local policy, and it was with the approval of the general counsel, who in fact ordered me to take it. And I said, look, why are you ordering me to take it? It's well within policy, and we're committed to this sort of thing. He said, but they're going to come after you, and if they come after you, they're going to have to come after me. But the point is that to have a kind of a peripheral attitude toward, I'm going to play on the sideline and let these other people handle things is not what I think the ACLU should be doing. And in fact, it's not doing that 99% of the cases. But in this area, it's frankly, it's having its problems. And I'll say nothing more critical, although I could be more critical.
Yeah, but yeah, Allison.
Two fingers on this.
Of course.
I think it's really important to look at the reason why the ACLU might take this different position today. And I can't speak for you, but the one thing I can see that's different between 1975 and 2025 is this immense optimization for profit social media ecosystem that kind of turbocharges our discourse and makes one argument that might be made in one context, rips it out of that, and then fires it out into the general public square without any attention to whether it's true, distorted, anything like. There's no mechanism to do that. Now, I am not suggesting we need a mechanism for government to intervene in our virtual public square. What I'm suggesting is that, and that's why I've written this book, is that if you look at the political history of content moderation at these companies, they're not following any rules. You can demonstrate this quite emphatically. They are optimizing for engagement because engagement increases their profit margins. And what engages humans, unfortunately, is when they're enraged. So in this sense, social media is like a rage machine. And it's not as though your voice is going out there. There's a whole set of algorithms mediating whose voice gets amplified for this optimization and whose is diminished. So in some sense, you've got this playing field in social media where some voices are loud as can be, and you can even set up a whole network like X, formerly Twitter, to amplify one man's voice, Elon Musk's, or you can completely silence someone through that same set of algorithms. So that's why Laura Loomer, for example, was so furious in the early days of the Trump administration because Elon basically deplatformed her. And he had the ability to do that without really saying anything publicly. You just change the dials on the algorithm. So I think this is an issue we're going to have to confront if we're going to be able to defend free speech in America.
So let me push you on that. That's just the $100 million question right now. So is there a line at which simplistic absolutist defense becomes harmful itself? And then what might we substitute in its place? You've thought about that.
Yeah, I have, and I've testified before Congress as well on this very point. And there's legislation, bipartisan legislation, to implement what I recommended, which would be to repeal Section 230 of the 1996 Telecommunications Act, which is what gives these companies both the ability to moderate content and then also to what's the best way of putting this? They are not liable for anything that's on the platform. In other words, third-party content, they're not publishers, they are platforms. And what that means is that they can both censor speech through those algorithms, and they're also not liable for any harms they cause. There are no companies in America that aren't liable for harms they cause in this sort of way. So to me, the simple answer would be just get rid of that law. Just sunset it. And everybody screams at me, especially in Silicon Valley. And Jeff Stone, and I've gone back and forth on this plenty too. But I think the answer I get the most frequently is that would change social, that would destroy social media as we know it. Yeah, I'm talking too loud. And my response to that would be, is that a bad thing? I'm not convinced that it is.
Emerson, you have a response?
Yeah, I mean, I appreciate the creativity, and I think, we have to, and so I'm not trying to say that we should not repeal, burn it down, metaphorically. I appreciate. I think repealing Section 230 would do far more harm than good. I think it's not just about maintaining social media the way we currently have it. It's about free speech on the internet more broadly. And so it's not my specific area of expertise, but there's a lot of ACLU resources out there about all the reasons that Section 230 is doing more help than harm in terms of free speech. But I think more generally in terms of sort of how do we navigate online speech and whether this is changing everything, changing nothing, somewhere in between, I think it's somewhat analogous to what we were talking about before, in as much as I have endorsed in the area of incitement the idea that we should stick with the principles, right? Like, it's true that communication is very different if you can reach 1 million people instantly versus not being able to do that, right? So what is imminence? What does communication mean? Obviously has changed. The modes have changed, the conditions have changed. But I think the principles should not be abandoned. And so I don't think we should be trying to rewrite free speech rules as much as adapting them to the modes we have at hand. And just, David, before we go, to illustrate the amicus point. So, one of my first cases at the ACLU involved Charlie Kirk, tangentially. So Turning Points USA was trying to start a new chapter at Arkansas State University. And they were being prohibited from tabling in the square, the central square, as I'm sure you're allowed to do here. And so actually, the Alliance Defending Freedom, who you may know as an advocacy group that stands on the opposite side of essentially every single issue from the ACLU, but they stood up for Charlie Kirk's right to speak and asked us if we would weigh in on their behalf in their lawsuit against Arkansas State and their anti-tabling policy, which created free speech zones on campus, which are the opposite of what they actually say. And so we thought about it internally, and we realized this was a really important issue. And in fact, for a long time, the ACLU of Arkansas had been complaining about this rule as a violation of the First Amendment. And the fact that it was going to be helping Turning Points USA didn't change our analysis of what was going on campus or what should be allowed and what should not be allowed. And what we ended up doing, and some might argue, I assume some in this room might argue, it was too cute by half, But we ended up filing on behalf of a different student organization called Peace and Love that had also been having trouble tabling and weighed in on the importance of overruling the Arkansas State restriction while also not necessarily having to compromise on sort of the other sorts of interests that we have as an institution. So I think this is an example. Some might say this as an example of the ACLU losing its way. I think of it as an example of the ACLU working hard to defend the principle and doing it in different ways. But I do think it was hugely important and impactful. And just in the argument yesterday, to the extent that you can think of amicus, I think you said David Goldberger standing on the sidelines. My colleague Ari Savitsky wrote an amicus brief in the Supreme Court, and they spent 5 to 10 minutes in the argument yesterday talking about it. So these amicus briefs can have significant impact.
David?
I want to be in the action. I want to be representing the client. I want to do what needs to be done to protect the First Amendment, and an amicus is simply got their hands tied.
I find myself in some sympathy with Emerson's, not his position, but his prediction of what would happen, in the sense that from the public interest point of view, all we care about is that some organization is doing the defense. And there is this quality of the ACLU, which is not true of FIRE and other organizations, which is a chapter-based organization. It's sort of responding to local democracy, if you will, or local preferences. So maybe to put a question there, Emerson, I mean, are there moments where that tension leads to cases where maybe the question is, how does that balance between the local and the national work out as a general matter? How do you guys select the cases where you're going to be amicus versus be on the front line?
It's a great question, and this was talked about earlier. Aria talked about the unique structure of the ACLU in terms of the affiliates. And it does add another layer, right? We're an institution that covers a lot of issues, but we're also a lot of places, and we have a lot of people involved. And so we both go through procedures. I mean, there's a lot of hand-wringing about one of the pieces of evidence that the ACLU had abandoned its principles was our case selection guidelines, which were published widely. And David, after this, let me tell you about my week and the arguments that I've had about directly representing. I'm with you. But what we do is we convene internally when there are potential conflicts among issues. I'll say, it's not just about free speech. This can come in, women's rights and the rules around investigations of harassment, right? This can be tensions between criminal legal reform and making victims whole. Like, there are all sorts of ways in which the various ACLU issues can bump up against each other, but it's true that free speech is often a part of it. And so what we do is we make sure that from all of our perspectives, including the affiliate perspective, everybody gets a chance to weigh in. We have very hard conversations sometimes, but I can assure you that we remain throughout those hard conversations, deeply committed to these First Amendment values and vindicating these interests. And I appreciate the impulse to dive in head first and be right there. I think the other reality is that, there are there are only really two organizations that represent people that they don't agree with, us and FIRE. There are other organizations that will represent people on First Amendment issues, but not if they don't agree with them. And so the sort of allocation of resources between the affiliate, between us, and FIRE, I am in very regular contact with those folks. Are you going to take this one? Are we going to take this one? Should we do it together? I believe the Arkansas State brief we might have ended up writing together. But many briefs we write together, many issues we coordinate around. So it's an internal process. It's an external process. At the end of the day, though, we do write the briefs. We do represent the people. I think many of the critics, if you'll see in the Times wrote, every sort of 9 months, the Times writes an issue, an article saying, where has the ACLU lost its way? One of my colleagues actually dug one up from every decade saying, has the ACLU lost its way? But if you look at it, what it says is, You know, the ACLU used to do all these cases, and now look at what its staff are tweeting. Which to me is a mismatch. Let's look at the cases. And if we can run through the cases, we keep a running list because we respond to these critics a lot. We do the work, we do the cases, direct representation and through amicus briefs. Some people wish it was all we did. Some people wish it was none of what we did. Some people wish it was exactly 50% of what we do. In reality, the really controversial, really abhorrent speech cases come up a handful of times a year. And we take them and we try to deal with them in a principled way.
By the way, no one look at what professors tweet. That's not a good thing. Okay. Just on that point about, yeah, please, David.
One of the reasons that Skokie became a benchmark, even though the case was never decided by the Supreme Court on the First Amendment principles that everyone recognizes it for, is because we were there in the middle and got the job done.
Yeah. How does defending these kind of cases, if it's a handful of cases, really extreme ones, why is that important especially in a pluralist democracy and a multicultural democracy? Why is defending a few haters important for democracy?
Well, this is an interesting point. I circled this when you said it earlier, Ari and I, that it didn't set precedent. And it's interesting, right? Because you're right, it didn't break any new line, it didn't move any First Amendment lines. But so much of our First Amendment work, with a big caveat for what you're talking about in terms of online speech, so much of what we're doing is holding the line, right? We're not, thanks to the work you all have done and your predecessors at the ACLU did, the lines have been set for a while now, several decades. And most of what we're doing is holding the line against the inevitable impulse of whoever's in power to abuse that power to squash dissent. So in that way, very, very few of our cases actually move the line in the First Amendment the way they might in other places. And really, most of what we're doing is defending those lines.
Allison, do you have an answer to the question of, this kind of extremist speech in democracy?
Yeah, I think it's really important to protect it for the simple reason that it gets amplified in ways that are often distorted. And some people can be shut down for allegedly arguing one thing, and it's been ripped out of context, and they're actually saying just the opposite. There are these, in the Charles Murray incident at Middlebury College, the Southern Poverty Law Center, and Nadine, you were there too. We testified in that panel with the late Robert Zimmer. I just lost my train of thought.
The Southern Poverty Law Center.
Yeah, they had this whole hit list of white nationalists, and they had defined Charles Murray as a white nationalist. And if you went through that list of what was on that, what he was charged of, they had these quotes. They were all ripped out of context. But yet everybody, the students, took that as the Bible for what this guy represented. And it had some pretty awful consequences. So there's the world is a complex place. It's always better to hear out people and do the best you can to empathize with them, or just turn away and not listen. You always have the right, if you think someone should not have a platform, to just not even listen. That's your right too. But to suppress speech is always a path away from democracy.
David, do you agree?
I agree, but I think the focus should be on the question of the power of government to suppress speech. That government simply can't be trusted, and if it can suppress speech that it regards as extremist speech, then who's going to define what extremist speech is? And at this point, we're watching a redefinition of that by our political leaders. And it seems to me that the correct line is no line except that which incites violence or directly causes violence.
Can I just say on that point, I mean, I only got to the ACLU in 2018. But for decades, we were doing a lot of like, what if the shoe were on the other foot? Like, can't you imagine? Yes, you love the president now, and you can't imagine a situation where X, Y, and Z might happen to you. But let's try to put the shoe on the other foot. This was like sort of the reflexive First Amendment exercise. And I do think I don't have to do that so much anymore.
Yeah.
Because the shoe is on both feet all the time.
Yeah.
And in the front page of the news, you are seeing lots and lots of controversial speech being punished. As you said, Nadine, under response, over response. The idea that the government might be wanting to repress your particular ideas, I think is not, unfortunately, it makes it easier for us as advocates to tell people that they should care, but it's unfortunate for our country that we are vividly seeing, as I said, the shoe on both feet.
Absolutely. I want to remind people that they can send questions to the Chicago Forum at uchicago.edu, and I have a few in front of me, which I'll turn to. So some of this is, again, about the ACLU. If the ACLU provides direct representation to some defendants rather than others based on the content of their speech, is that a form of viewpoint discrimination? Even the choice between amicus and direct is in some sense, a choice. So how do you respond to that, Emerson?
Well, David Goldberger would say we're not the government.
Yeah.
So we don't. So the content discrimination is not relevant. But no, the point is, I was trying to be candid, and this is what happens when you're candid.
Yeah, no, it's good.
The decision is complicated.
Yeah.
It's not that we, amicus if we don't like them, direct represent if we do like them. It's not that simple. I didn't mean to paint that type of picture. It's a very complicated process. It's who's going out on parental leave? Like, is the affiliate supportive? You asked about affiliates earlier. They range widely. They range from affiliates with 4 people and 1 attorney to affiliates with 100 people and 30 attorneys, right? And they range from, very strongly, maybe they have 2 or 3 attorneys who are great First Amendment attorneys, and you might have other affiliates who really have deep problems with some of like ACLU positions on the First Amendment. So it can vary quite widely depending on the situation you're in.
This question, I hope I can capture it. How might we respond to situations where organizations attack the principle of free speech by making controversial presentations that are actually calculated to weaken support for free expression on campus? Is there a distinction to be made based on such disguised attacks? I don't know if that's clear enough, Allison.
Yeah, no, I understand what you're saying. I think one of the things that's often misunderstood about free speech issues on college campuses is that many of the provocateurs who have largely appeared at public universities are not invited by students. There are often outside groups involved in trying to get a place to hold this talk. And, a public university has to, if they have a rule for renting a space, they cannot discriminate on the basis of viewpoint because they're public institutions. And so my view, and I think it might be Jeff Stone's view as well, is that if a faculty believes that an event on a college campus is worth engaging, that should be the decision point. If there's at least one faculty who thinks it's worth engaging, it should be allowed to be held. But I don't think outside provocateurs should be able to exploit people's views of universities, which is very much the case.
Right, but the difficult point becomes when there's an outside provocateur with no sort of genuine academic idea that nevertheless, gets one professor to say, yeah, we'll support you. Do
you have an example of that, though? It's really hard to come up with one.
Well, let's just take Milo Yiannopoulos, person with no idea.
Yeah.
I'm willing to be in the public record of saying that.
I will second you.
Suppose there's someone who wants to perturb the environment or make a demonstration that we really believe in free speech, so we're going to invite him. Mm-hmm. Now, his point is just to provoke a riot.
Yeah.
But then what do we do? I mean, I guess what I'm asking you is, would it be okay for the central administration or the community of faculty to say at some point, this person really doesn't have an idea?
Yeah.
It's not a genuine academic engagement.
I can't think of a single case where that's the case, and I've said before Congress as well that no faculty member I know of would ever invite Richard Spencer to campus.
Yeah.
I could be proven wrong. I can always be wrong, but I think we underestimate the judgment of the faculty on deciding who should and should not speak. And the administration, when they get involved, they're just very much worried about how it's going to appear, and oftentimes it's not the proper concern about first principles and what the university represents as a truth-seeking organization.
David?
If I understand your question, I cannot understand why a university should, if a student organization wants to invite a speaker, if a faculty member wants to invite a speaker, I don't think that there should be any standard other than incitement of riot or disruption of the educational process that should govern administrative review of the content of the speaker to decide whether that speaker can come.
So this is, agreed.
Yeah.
And so this is where I get to be the free speech absolutist. What first?
Yeah.
David Goldberger. We represented directly Milo.
Yeah, there you go.
Did you?
We did.
Interesting.
So if for anybody who was worried that we don't represent obnoxious people, we directly represented him. And I also 100% agree with you that no, that should not be a line that we should be drawing in terms of campus speakers. What it brings up to me, which is I think a little bit of a harder question, is the related question around academic freedom, right? The Supreme Court has said that academic freedom is a special interest of the First Amendment, but they are not coextensive, right? So when we're talking about speakers, who's allowed to speak on campus, I think that's much more of a free speech issue than an academic freedom issue, and so I would hesitate to impose any sort of academic litmus test on that. Mm-hmm. But there are situations when we're talking about scholarship, research, and we think about viewpoint discrimination and content discrimination and the government's role and who is acting on behalf of the government, particularly in public universities, and is a dean's judgment about the value of someone's scholarship really a viewpoint-based issue. So I do think that sort of where invalid views, how invalid views or sort of unsupported views are treated under academic freedom is actually different than how they're treated under the First Amendment. So I think, a tenure committee might reasonably sit around and say, this person's scholarship is not valuable, and therefore, in some sense, I'm judging their ideas to not be good, right? And I'm going to not promote them because of their ideas. So in some sense, that is viewpoint discrimination. But I think if you start pushing that into public speakers and only those who have views that are accepted within the academic community can speak, I think that becomes quite problematic.
Yeah, I totally agree with you. But I think that faculty rule is a good one, and maybe I'm coming from a perspective of spending a lot of time with 18 to 21-year-olds. They come up with some crazy ideas that might let them collaborate with faculty. You can really find a faculty member to
do almost anything?
Yeah.
if the student is respected, by the faculty member.
I can also imagine faculty members who would
I did that, for example.
Enthusiastically support students to bring someone even with whom they didn't agree and didn't think was a worthy debate opponent, for example.
Yeah, that's what I did with Charles Murray. The students invited the speaker. They said, we know he's controversial. We want you to ask the first 4 or 5 hard questions. And I thought, of course I have to do this. I'm a political scientist. We're not the Department of Propaganda. We've got to entertain alternative viewpoints, and let's model what that looks like for students.
Right.
That didn't go so well, though.
I think faculty should serve that sort of gatekeeping in their work and in their scholarship, but I think not in campus speech more generally.
Yeah, they are really different. I mean, one of the problems is in our world, in the United States, unlike many other countries, we don't have a separate right of academic freedom. It's all sort of penumbral in this First Amendment stuff, and that leads to some confusion.
Yeah.
Send questions via the email, if you would. Allison, some have argued that repealing Section 230 would lead to overly overly intrusive content moderation restricting speech, or alternatively no moderation, in which case it's just all algorithms at that point. So what kind of moderation do you think would best protect First Amendment values, I suppose, in the digital public square?
I actually don't think it's possible for private corporations to do that. They are always going to be more attentive to their bottom line than to these values that are so important to us. But I think here we could make like kind of an originalist argument and say that what we really need to do is go back to the First Amendment itself rather than existing First Amendment jurisprudence and ask, what was the founders' intent? And I'm pretty sure they could never have anticipated, protecting the speech rights of algorithms or machines. These are human rights. And I think you could really start tackling. So what Section 230, in my view, has done is it has, in a sense, cordoned off First Amendment jurisprudence from one of the most important issues of our time. And I would like to see the courts contend with that in a thoughtful manner. So, as for what could happen, it could destroy social media as we know it, but there are all sorts of attempts now underway to provide a more decentralized sorts of platforms that could perhaps support truth-seeking, could give users a voice, choice, and a stake in what's going on those platforms. You could reimagine what that space should look like. And, my own view of it now with Larry Ellison about to have a big hand in TikTok, and there's a really chilling process going underway right now that we have to somehow create something better that we can point people toward if Section 230 was revealed, because I think that would be an enormous catalyst to move us into a new round of innovation and hopefully one in which human rights are fully supported and protected.
Yeah, I think doing away with immunity, the problem is that I don't know that you would be too scared to create anything to replace what had been taken away, right? Because
if you use decentralized protocols. I think that I'm not suggesting that you don't understand technology. That's not what I'm trying to suggest.
Please feel free.
But this is really this has become a very difficult issue because some of the technological advances are quite difficult for English majors to understand, unless they're unusually dual trained in STEM fields. So part of the big problem that we have is translating for the general public what the alternatives actually are before them. And that's why I've written this book, Who Elected Big Tech. I'm trying to do that. I don't know if it's successful, but I'd love to get your feedback.
Yeah. Well, the only follow-up I would say is that I don't mean to, we are quite strong in our position, but we do not dismiss any tweaks to Section 230 out of hand. We also have a legislative wing, and we're talking about repealing 230. You could also amend Section 230. And I think there have been lots of proposals for tweaks that can be made, changes that can be made, and every time they are proposed, we discuss them deeply and figure out whether this is something that we think would help more than hurt, and whether this is something we can support or we're going to sit out. So it's an active debate, and we have taken a position, but we continue to reevaluate, not so much repeal. I don't think we'll ever get to repeal, but if there are tweaks that can help, we are always open.
I would love to come and brainstorm with you.
My colleague, not me, but yes.
One question that came in is similar to something I asked Aryeh, which is about the universality of these principles. Everyone, of course, likes free speech all over the world. It's core to democracy. But does that mean is the American approach universal? We have made it so because we invented the internet and we've exported our libertarian content all over the world. But, couldn't we have different cultures, different democracies come to different answers on questions such as those of hate speech?
Absolutely. I mean, I'm curious to hear from other panelists as well, but my background before I came to the ACLU was actually in international human rights law. Oh, wow. And I first started working on freedom of expression in sub-Saharan Africa, working all over the continent on regional norms and specifically laws that govern freedom of expression, freedom of assembly, and freedom of association. So that's like the right to form organizations and advocate and protest and those sorts of things. And the reason that I sort of became so passionate about free speech was working with activists, LGBTQ activists in Uganda, environmental activists in the Congo, democracy activists in the Gambia. And they were getting, and democracy activists in Tanzania were getting locked up for criticizing their president on Facebook. One of my colleagues called the president an idiot, President Magufuli, and he was thrown in jail. Mm-hmm. We think of this as, such a wild situation that it could never happen here. When I first started working in the United States, I would tell these stories and people would sort of lose interest. Not anymore. Mm-hmm. There are lessons that can be learned. And so all this is to say that what was happening there was the government had no restraints on its power, right? This is what happens in societies when there are no constraints on the government's authority to regulate speech. So as you said, David, I always come back to, yes, of course cultures are different. Of course legal systems vary. Of course societies vary. Of course there's many ways that we can talk about and think about these things. But at the end of the day, the idea that we need to restrain the government's impulse to quash dissent, I do believe is universal. And working in Africa, you hear a lot about criticism of international human rights as Western imperialism, neo-colonialism, and there's a lot of truth to that. In terms of the human rights regime and the way that the funding flows and all, there's a lot of criticism of international human rights. But when I went and traveled around and talked to activists, and not just activists, but folks who are trying to improve their communities, whatever they felt about international human rights, the United States, Western norms, values, culture, they didn't want to be locked up for criticizing their mayor. They didn't want to be locked up for protesting in the streets, and they didn't want people being disappeared just because they dissented from the government.
Yeah.
Can I add that REA really put his finger on the main point, I think, when it comes to regulating speech on university campuses, and it's a broader point that's applicable here, and that is that it should be evidentiary based. Is there going to be actual provable harm rather than hurt feelings or upset or even offense, profound offense, as anti-Semitic statements are profoundly offensive? Is there going to be actual harm? And that's a universal question, not a question that the facts of the harm may vary from situation to situation. They always do. But the underlying question is, there should be can be the same standard in order to protect speech.
I'm going to ask a final question, which is directed at Allison. Mm-hmm. So your vision of campus is that the professors ought to have basically universal rights to invite everyone. If a student group wants to invite someone, they've got to go get a professor. I trust this question came from a student. Why have the rule at all? Why don't you trust students to make the judgment themselves, registered student groups and such?
It's a great question.
I thought so.
You're not on your own campus right now.
Yeah. I'm not questioning the judgment of 18 to 21-year-olds about knowing what interesting speakers to bring to campus. I just know that if we encourage faculty-student interaction on the extracurricular activities, all these other positive effects result. So I don't think that's that big a... The alternative, by invoking that rule, I'm trying to prevent the administration having the right to make these decisions. Mm-hmm. And I think it's kind of like a practical compromise, because I don't think it's hard to go get a faculty to work with you, member to work with you. It's not meant to somehow cast judgment on the ability of students to know what an interesting speaker is. They have great ideas.
I'm really
it's more
excited.
practical.
I'm really excited for you to meet some of our University of Chicago students. As
Yeah,
students.
yeah.
And with that, I want to again thank the Zell Family Foundation for their support of the event, thank all the staff who participated, and please join me in thanking the panel.